Okay, hi everyone. To our friends in Singapore and the region, a very good morning to you. And to our friends across the globe, as I understand from Germany, France, even Nigeria, it's wonderful to have you with us. So a good evening to you. Thank you for joining us today on this discussion on patenting artificial intelligence. My name is Marcus and I'm the General Counsel of Slate Alt, an investment platform focused on innovative deep technologies. And I'm also a volunteer here with Hello Tomorrow, a global organization on a mission to accelerate deep technology research and entrepreneurship, and to bring breakthrough innovation to commercial scale. This event, I'm very glad to say, is co-organized together with A-Start Central. And you can find out more about us and A-Start Central on the social media. So next slide, please. So if you'd like to learn more about A-Start Central, the innovation platform of A-Star and Hello Tomorrow, do follow us on social media on Facebook and on LinkedIn. So as an administrative announcement, please submit your questions in the Q&A box rather than the chat function so we can better track your questions and get to them. You can feel free to ask any questions at any point of time during the session. This event is also recorded, so you will be able to find it on demand on our YouTube channel shortly after. Next slide, please, Susan. Next slide, please. Yeah. So this event on patenting AI is actually the first of a three-part series on artificial intelligence and intellectual property. So we will be having an interesting discussion on AI personhood as the second session on 15th October. And we will also have a workshop on the 5th of November to help you develop your IP strategy. If you'd like to find out more and sign up, do scan the QR code or visit our website at hello-tomorrow.sg. Okay, with admin announcements aside, we'll finally go to the meat of the matter, which is on patenting AI. So we'd just like to see the composition of people here today. So we're just going to conduct a poll of people to see what profile you come under. So please help us issue the poll. So as you know, we look at patenting AI, most of us would actually have seen the proliferation of AI in everyday applications around us. And with that, we now see an increasing number of AI patents filed in the international and also in Singapore. According to a United Nations WIPO study, the number of patent applications and publications for AI has increased about 28% on a year-on-year basis since 2012. And just to put some numbers to it, we've actually seen an increase of patent applications from 8,500 in 2006 to over 55,000 in 2017. That's more than a 500% increase. So we just like to see who is in the session here today to see how this event might be relevant to you. So we see, okay, most of us are actually within corporate settings. Quite a number of us also are startups and researchers. So, and tech transfer officers as well. Fantastic. So this is actually would be a quite relevant topic for all of us here today, especially for those who are in the research elements of it. So I can't think of anybody better most immediately to share about this topic than my friend here, Dr. Kim Sinson. So Ken is actually currently the principal at Davies Collison Cave, one of Australia's largest IP firms. Ken assists innovative organizations to obtain patent protection and to develop IP strategy across a large range of industries. And he's a registered patent attorney in Singapore and in Australia. Now, if that were not enough, Ken also has the achievement of holding a PhD in physics and has postdoctoral research experience in bioinformatics. So I'll pass the time over to him for a half-an-hour presentation. Feel free to ask your questions as we go along, and we will discuss some of the more interesting questions at the end of the presentation. So I'll pass the time to you, Ken.
Thanks a lot, Marcus, for that very kind introduction. So it's a real pleasure for me to be here this morning, evening, afternoon, for some of you to present on this very interesting topic, which is very close to my heart. I advise a lot of innovators in this area. So it's an interesting topic, and I can already see there's some interesting questions have come through, which we'll field later. Next slide, please. So just to give you a bit of a brief recap of IP rights to provide some context for the discussion today, while we'll be focusing primarily on patents, it's important to note that there are other IP rights that are relevant to computer implemented technology, including software that has AI aspects to it. So any software is automatically protected by copyright because it's considered to be a kind of literary work. However, just like copyright for other kinds of works like books and photographs, this type of protection can be quite limited because it only covers the specific form of the code, the literal expression of it, rather than the ideas that are embodied in that code. So that's why we talk about patents for software and why they can be important for software, because they protect what the software does, its functionality, rather than the specific way that it's written, provided, of course, that the other patentability requirements are met. We'll explain what those are in a moment. So another limitation of copyright is that you need to be able to prove that the infringer had access to your work and actually did copy it. Whereas with patents, you don't need to do that. All you need to do is to show that the infringer's product or process, whatever they're selling or making, works in more or less the same way as what you've claimed in your patent. So they don't actually even need to be aware of the patent to infringe it. So an important difference there. Now, another important form of IP rights is trade secrets. So a trade secret is confidential information that has value to your business and which is actually secret, so is not known to the public. And where you have made diligent efforts to keep it a secret from the public. So trade secrets aren't registral rights, they arise through common law. And so the way that you protect them is through legal agreements such as NDAs, but also making sure that that information is physically secured and logically secured, so that appropriate access controls are put in place to prevent outsiders from accessing the information. But also importantly, to make sure that only those people internal to the organisation have access to the information and that any such access is logged. So in principle, you can keep trade secrets forever. So there are examples such as the recipe for Coca-Cola. But you can't guard against someone else inventing the same thing independently. And you also can't guard against somebody reverse engineering your technology. So that's the kind of trade-off. So in fact, it might be the case in some cases that a patentable invention can be kept as a trade secret as an alternative to patenting. So you need to make a choice as to whether you patent or go via the trade secret route instead. And while I haven't mentioned it on this slide, it's also important to note there's another type of IP right, which is trademarks, and any business has a trademark, whether that's a word or a logo, which is used to signify the connection between that business and its products or services. So that's not specific to AI, but it is something important to keep in mind. Next slide, please. Okay, so I talked about needing to meet certain requirements for being able to patent something. And what are they? Well, the first one is that the invention has to be novel. So it has to have at least one feature that distinguishes it from what was already known to the public at the time you filed your patent application. And we call that previous knowledge the prior art. So generally here we're talking about the invention needing to be new in light of a single publication, whether that publication is a document, a printed document, or an electronic document such as a web page, or even a public use or public sale of something that embodies the invention. So this public disclosure, the prior art, can also include anything that you disclose yourself, which is why it's very important that you file a patent application before you disclose any details of your invention to the public to prevent any issues from occurring with patentability. So the next hurdle we need to overcome is that the invention has to be actually inventive. And another way to put that is that it has to be non-obvious in view of the prior art. So that is, if I'm given that prior knowledge, the prior art, as my starting point in the context of a problem that I'm trying to solve, would it be obvious to get from that starting point to my invention or the solution that's embodied in my invention? And so as you might think, this is can be quite a subjective assessment that's made either during patent examination or during patent litigation, and it can be quite a contentious issue which can require expert evidence to be brought in and be quite difficult to deal with that issue. So another important requirement is that the patent is sufficient. So what does that mean? It means that your patent specification, so the document that describes your invention, has to provide a detailed enough recipe for somebody to be able to make the invention. And the reason that we have this requirement in patent laws around the world is that it's part of the quid pro quo with the government, which is the body that's giving you the patent rights. So in return for the 20-year monopoly that the government gives you, you provide a detailed enough recipe for the public to be able to reproduce the technology or to have access to the technology after your monopoly expires. So that's part of the bargain that you make. And last but definitely not least, there's a threshold requirement in most jurisdictions that the subject matter of the patent has to be of a kind that is suitable for patenting. So for example, in Europe, a mathematical method as such is excluded from patenting unless that mathematical method gives rise to some sort of technical effect or technical contribution, or there is a technical context in which that mathematical method is used. So you can't patent the mathematics itself. So for example, if you devise a new type of support vector machine, that in itself will not be patentable. But if you're applying that mathematics to in a specific context for a technical purpose, that could be patentable. Now, the word technical comes up in European patent law a lot, and also in the UK and some other jurisdictions. But unfortunately, there's no clear definition as to what is technical and what isn't. So you kind of need to be guided a little bit by previous examples of what has been found to be eligible for patenting to get some idea of where the limits are. So that's the approach in Europe and some other jurisdictions such as China. What about the US? Well, in the US, since 2014, when an important Supreme Court case called Alice was decided, we often face objections that software-related inventions are directed to an abstract idea. So usually what this means is that the examiner or the court thinks that you're defining your invention so broadly that you're claiming the concept itself rather than the application of the concept. So once that type of objection is raised, it can be quite difficult to overcome. And in fact, in general, this subject matter eligibility requirement can be one of the biggest difficulties to overcome for AI-based inventions in many countries. So we'll illustrate that with a couple of case studies in a moment or two. So all of that being said, what aspects of AI-related technologies could be patentable? Generally speaking, the more specific you are in the way that you define your invention or in the type of invention that you try to protect, the more likely you are to succeed. So it can be pretty difficult to patent what I might refer to as a fundamental algorithm, such as an SVM, because patent offices will generally treat that as being directed to a mathematical method as such, or as being too abstract. So you need to provide a link between the algorithm and some technical or real-world effect. So to give an example here, if you developed a new neural network architecture that made it possible to do deep learning in resource-constrained environments, that novel architecture might be argued to provide a real-world advantage, and that might be one way to argue that it's patentable. but in most cases, fundamental algorithms as such can be difficult to patent. On the other hand, it's generally possible to patent algorithms that have broad ranges of application that you might refer to as platform technologies. So for example, a pre-processing method that helps to prepare input data in a way that results in more efficient or more accurate classification could be patentable. Another example would be things like low-level image processing methods, for example, compression or noise removal that can be applied to many different kinds of image and that aren't industry or technology specific. And there are also things like bioinformatics methods used for biomarker discovery or predicting binding sites of proteins, which are generally applicable and not restricted to use for a specific disease or other particular application. And even more narrowly than that, and generally the most straightforward cases for patenting are specific applications of AI, where it's being used for a specific technical purpose, such as, for example, predicting likelihood of a particular disease based on medical imaging data, controlling a specific machine, such as an autonomous vehicle or a medical device, or possibly even in some cases, simulating a technical system for a technical purpose. And one example of that might be a virtual wind tunnel for simulating aerodynamic characteristics of an aircraft design. Next slide, please. So let's take a look now at some examples of AI-based technologies that have been successfully patented. If we can move on to the next slide. So the first example that I have is a Mitsubishi patent that uses recurrent neural networks to determine a motion trajectory for an autonomous vehicle based on time series data. So that data is obtained from sensors on the vehicle that both record environmental factors, such as the motion of external objects, such as other vehicles, but also sensors that record internal parameters of the vehicle. So the invention here is based on the realization that most of the information about the vehicle's environment doesn't need to be used for determining the trajectory if you apply certain known constraints to that vehicle. For example, the trees and other objects that are off-road shouldn't be taken into account for determining the vehicle trajectory because the vehicle is constrained to move along the road, so you can disregard that information. And so these types of constraints are encoded and used as inputs to the neural network, and the neural network is trained to output a reference trajectory that the vehicle should follow, having been trained on trajectories that have been taken by various vehicles previously. Now, there's another part to this algorithm, which is once you determine that reference trajectory, working out the control signals that should be taken by that particular vehicle to achieve the motion trajectory that tracks that reference trajectory subject to the constraints. So this additional step of determining the control signals happens outside of the neural network as a post-processing step. And why is that important? Well, it means that you can disentangle the specifics of that actual vehicle's dynamics from the neural network itself. And so you can use the same trained neural network to determine trajectories for lots and lots of different types of vehicles without worrying about the exact way that the vehicle is going to follow the trajectory. So that two-part process is the kernel of this invention. And this patent was granted in several countries, so in US, Europe, and Japan. And it didn't encounter any difficulties in relation to patentable subject matter. It's a clear example of a software invention that operates within a technical environment for a technical purpose. So software that improves the operation of a machine, such as an autonomous vehicle, is clearly patentable subject matter nearly everywhere in the world. Next, we'll look at a different example on the next slide. That relates to the field of medical image processing. So this patent was granted to Siemens in the US, Europe, and China. And the problem being addressed by this invention is how to obtain an accurate measure of blood flow in an artery to diagnose coronary artery disease. So previously this was done by methods such as inserting a pressure wire into the artery, or to construct a physical model of the artery based on imaging data. But these known methods have their disadvantages. So the first one is obviously an invasive procedure, and it can be also inaccurate because insertion of the wire into the artery can disturb the blood flow and give you an inaccurate reading. And the second method, using physical modelling, has limitations in terms of computational cost and complexity, and it also makes limited use of the available information, such that you may not obtain the most accurate results that you can. So what the invention does is solve the issues with the prior art by predicting a hemodynamic parameter such as fractional flow reserve, or FFR, directly from image patches of a medical image of the stenosis, which is a narrowing of the artery in the patient. And it does that using a deep neural network regressor. So the source image can be any type of medical image. It can be a CT image, an MRI image, an ultrasound, whatever. But the important thing about this invention is that it finds image patches in the source image that contain the stenosis. And it can do this in a number of different ways. So one example in the patent is using marginal deep space learning or marginal deep space regression. And these image patches can then be passed directly to a deep neural network to compute the FFR value. So the FFR value then gives you an indicator of potential coronary artery disease. So how is this invention treated by patent offices in different countries? Well, in this case, the patentee, Siemens, actually had more difficulty with patentable subject matter in the US. So the US examiner looked at the way the invention was defined and said, well, you have a process here that is performed entirely within a computer system and outputs a numerical value, which is a mathematical entity, and it doesn't use that numerical value to control something outside of the computer system. So here we have a difference from our autonomous vehicle example. So the US examiner felt that this invention therefore related to an abstract idea in that it didn't have enough of a real world connection. And what that meant was that Siemens had to go through several rounds of argumentation with the examiner to try and convince him or her that this wasn't in fact an abstract idea, but was a concrete application of a mathematical method or of computer technology. And eventually they were able to succeed, but they had to narrow down the scope of their invention. So they had to narrow the way in which the invention was defined to a specific way of training the deep neural network and arguing that that specific training method was an unconventional use of computer technology. So they did get something granted, but it was narrower than they would have liked when they set out on the process. Now in Europe, on the other hand, Siemens didn't have any difficulty with patentable subject matter in the way that it was examined by the European examiner. So the European Patent Office considers images to be inherently technical objects. And so processing such technical objects for a technical purpose, which in this case is calculating a physiological parameter that's relevant to disease diagnosis, is patentable. And as well, in China, the Chinese Patent Office tends to follow a quite similar approach to Europe, where they treat technical applications or technical solutions to technical problems as being patentable subject matter. And so Siemens didn't have any problems in China either. So just an illustration of the way that different laws can impact on patentability in different countries. And my final example, which also illustrates this point, and which is on the next slide, is related to search engine technology. So this is a Microsoft patent that was granted in the US and in China, but was rejected in Europe. And Microsoft elected not to fight against that rejection. I'll explain why. So the invention here is a search engine that can provide search results that take into account a context in which the search query was submitted. So the idea is that by capturing the context of the query, the search engine should be able to provide results that are more relevant to the user. For example, if the query text has been selected in a document, the context can include text that surrounds the selected text in that document. More generally, the context could include other information such as demographic information about the user, information about previous queries, and the time and location at which the query was submitted, and so on. Now, as you can see from the figures reproduced on this slide, the invention uses a deep learning model to transform the context information to something called a concept vector. It applies the same deep learning model to a set of target documents to transform those to concept vectors. And then it compares the context concept vector to each of the document concept vectors to generate a relevance score that indicates the semantic relatedness of the context information to the target documents, so that you can return a ranked list of target documents as the results of a search query. Now, I should note that the detail of the deep learning model provided in this patent specification is pretty sparse. Apart from figure 8 on the right of the slide and some brief discussion of the layers of the network, there's almost no detail provided of why and how the deep learning model is relevant to the invention. In fact, the patent even says that there can be any number of layers to the deep neural network. So it may even be the case that any deep neural network architecture will suffice for this invention. So as I mentioned, this invention was treated quite differently in the US and Europe. So the US patent examiner had no issues at all with this being patentable subject matter. The only objections were raised on the basis of obviousness, and Microsoft were able to overcome those by more narrowly defining their invention to clarify how it was different from the prior art. In Europe, on the other hand, the examiner rejected the application because the output of the search engine was considered not to have any technical significance. So the content of the documents and their rankings in the search query results had no technical meaning, but are only of significance to the human user who inputs the query. So it was held that there's no technical purpose to the invention, and thus that there was no patentable subject matter here. Now, the examiner also highlighted the point that I raised before about the lack of implementation detail for the deep learning model, and assumed on the basis of that lack of detail that there wouldn't be any difficulty in implementation such that the deep learning aspect couldn't contribute to patentability here. So given that there was no detail described, it was clear that the deep learning aspect was not really part of the invention. So I think the moral of the story here is that detail is particularly important, and especially in cases where you might have an application of AI which is arguably non-technical, such as in the financial sphere or in this case, search engine technology. If you can provide more detail about things like the way that input data is prepared for input to the algorithm, or how the algorithm is trained, then you may have a better chance of obtaining patent protection in Europe, and certainly in some other jurisdictions too. So hopefully that illustrates a little bit where the boundaries might be between patentable and non-patentable subject matter, and how you might overcome some of the issues and couch your patent application in a way that sets it up for better success. So another question with AI technology is whether you patent it at all, and if so, what aspects you might patent and when. I spoke briefly about the choice you sometimes have to make between patenting and trade secrets, for example. And now, what should inform that choice? Well, one important consideration is obviously whether the invention is likely to be patentable or not. We talked about some of the factors that will help to decide that, especially the subject matter issue that I've discussed at some length. But there's also other patentability factors that you need to take into account, such as novelty. So before making any patenting decision, you need to, or it's a good idea at least, to do at least some brief searching to get an idea of what else is out there that may affect novelty or obviousness of your invention. Now that should be done at a relatively early stage, and preferably in consultation with an expert such as a patent attorney or a search specialist. Now, another thing to consider here is if you were to obtain a patent, would you be able to work out whether it was being infringed or not? For example, if the invention is implemented essentially as a black box, how are you going to detect whether other people are doing the same thing? Now, if the answer is that it would be difficult or even impossible to detect, maybe patenting isn't the right approach, or at least patenting the algorithm may not be the right approach. On the other hand, there could be situations where an algorithm is being used to control behavior of a machine, and it might be possible to work out by observing the behavior of the machine how the algorithm works. And there could also be innovations around devices or methods for doing things like collecting data to input to the algorithm that are more easily observable than the algorithm itself. And those could be alternative or better candidates for patent protection. So a related question is, who would actually infringe a granted patent? Would it be a startup? Would it be a public research organisation such as a university? Would it be a large company? Who will the patent keep off the market, and who would be a target for licensing? So the deeper the pockets of the potential infringer, or the more directly they are in competition with you for market share, the more likely it is that a patent will be a valuable asset for you or for somebody who invests in you or who licenses the patent from you. So you might never be in a position to enforce the patent yourself, but it could be a very useful weapon in the arsenal of someone who buys or licenses the patent from you. And you should also consider what the potential useful lifetime of any patent will be, bearing in mind that it can take several years for a patent to be granted. If it protects a feature that is only likely to be of interest to you, or only likely to be of interest in the industry generally for a short period, then maybe patenting isn't worth it. So as a counterpoint to patent protection, how about trade secret protection? Well, this can be a strategy that can be effective, provided you do actually, for a start, have the ability to keep the technology secret. For example, as I mentioned before, if someone can't reverse engineer the technology and you have adequate security and access control in place, this could work quite well, especially where the invention may have a short life cycle, as I just mentioned. Now, there obviously is a risk to employing trade secret protection as your main strategy, the risk of information leakage, the risk of somebody taking the trade secret, moving to another company and deploying it there, as we've seen in some prominent cases, such as the Tesla litigation in the US recently. There's a further risk that somebody could independently invent something similar and patent it, and that patent that they obtain could potentially block you. So you need to weigh these risks against the potential value of keeping things confidential. Now that brings me to another point on this slide, which is legal validity against the need to disclose. So as we talked about before, there's this sufficiency requirement in patent law. You need to tell everyone in your patent specification how to make the invention. So there can be a tension between disclosing just enough for people to make the invention without giving away your secret sauce about some important implementation details. For example, how to optimize your algorithm to work on particular hardware platforms. So this is something you need to take into account and something you should get advice on before you make any decision as to whether you patent or not. Now, as well as your own perspective, patenting decisions might be informed by the perspective of other stakeholders, such as investors. So many investors expect that companies that are underpinned by new technology will make efforts to patent that technology. That may or may not be a reasonable expectation, but you need to be able to explain your choices. So why have you patented some things and not others? If you haven't patented at all, why not? Do you have a clearly articulated strategy around IP protection and management? What are you doing to protect the competitive advantage of your business and to build a moat around it? So I'm in danger a little bit of preempting part 3 of this series where we discuss these issues in much more detail. So perhaps that's a good point for me to stop and for me to hand back to Marcus now so that we can field some of your questions.
Thanks, Ken. I really enjoyed, in particular, all the examples that you gave. I think right now what would be good is to actually address some of the questions that we received even before this entire event. And we've read all your questions. I think one of the most interesting questions that was asked was, how good is a patent actually? So, we've been talking about the subject matter, but what good is it if the effectiveness is limited? Are there any limitations to patents? I know you covered a bit, but maybe we could expand it a little bit more.
Yeah, sure. So I think one of the issues that I mentioned, which is particularly tricky for AI inventions, is this kind of black box issue where you might not know how to find infringement or not. So I guess if you're looking to patent, excuse me, the algorithm itself, that could be an issue for enforcement. What I would say is that a granted patent or even a pending patent application can have some deterrent value, even if you don't actually enforce it or never even intend to enforce it. By having that patent, you've kind of codified what you do, and you put people on notice that, hey, we are actually serious about protecting our IP, and this is something that we can enforce against you if we find out that you infringe. Now, the other thing is that you may never intend to enforce the patent yourself, right? But it's still a useful business asset. And if somebody is looking to invest in you or even to acquire your company, that might be an asset that they would want to have to be able to enforce or license against the competition or other players in the industry. So these are 2 of the reasons why you would patent. There are many others too. One reason is kind of a marketing reason to say, to endorse your technology. Basically, we have patent pending or patented technology, and to be able to tout that. So, yeah, many different reasons.
So one of the things I was actually asked recently on a very similar patent issues that you were mentioning, I guess there's 2 major downsides, right, to patents, to filing patents for AI. The first would probably be the fact that once you reveal this technology and your patent isn't successful, technically, would it be the case that this is free for all now? There's that real risk that your technology is out there. Even if you want to keep it secret, you can no longer do so.
Yeah, that's absolutely right. I mean, that's certainly a risk that you won't get a patent and then others are freely available to use what you've disclosed. So then it comes back to that point on validity versus disclosure that we talked about, which is if you can hold some really key details back that preserve your advantage in some way, then you can still try and get a patent for the kind of overall functionality, but there might be some other stuff that you can keep secret and still give you that advantage. So there's kind of a tension between the 2, and you need to weigh up whether it's worth it or not to disclose kind of the algorithm details or the kind of functionality of what you do.
So even if one does get a patent, is there, how does enforcement look like? What would that process be, and how much money technically would people actually need to pay to use that hammer of enforcement?
Yeah, well, I mean, enforcement goes in several stages, right? So you don't immediately issue a court action. So normally you would have to do some investigation to be reasonably comfortable that there's a realistic chance of it being found to be an infringement, so that it falls within what you claim in the patent. You also need to do a bit of due diligence on your own IP just to make sure that it's valid. So maybe some extra searching and just making sure there's no issues with ownership, this kind of stuff. That's stage 1 before you even do anything. The next stage is, okay, we think there's going to be infringement, so we're going to put the infringer on notice and say, hey, did you guys know we have this patent and it looks like it covers what you guys do? Do you want to talk about taking a license from us or stopping? So a cease and desist, basically. Now, if you get no response to that or an unsatisfactory response, that's when you actually have to issue court proceedings. And that's where it can get very expensive. And especially when you start bringing in common law countries such as Singapore and the US and the UK, where you have to bring in a lot of expert evidence about, we talked about the obviousness issue and judging whether something is obvious or not, interpretation of the claims, these kinds of things. And discovery as well is a very expensive process. So actually getting access to the infringers, documents and emails and whatnot to find out what they are actually doing to prove infringement, that's the expensive part of the process. So it can be, hundreds of thousands of dollars to enforce a patent, which is why most people don't do it, right? So big companies do it, startups are never going to do it. But, like I said, if you still have that patent, that's a business asset, which is a tradable thing. It's saleable, it's licensable.
So there's actually much greater dimension, right, to this entire process. I think the problem that quite a lot of people tend to look at is, hey, I have a patent, I can do whatever I want, and no one's ever going to infringe my patent. But as you shared, it's actually really not the case. If people can't even detect the infringement, then what good is your patent, right?
Right.
So I think that's actually one of the questions that's been asked by Rory Welding. He said, can you expand on the can you detect infringement with algorithms? It would seem almost impossible unless someone can actually look at your architecture. What practical advice do you think you could give or you would give?
Yeah, I mean, it is really difficult. I would acknowledge that. I think, you sort of have to look for indirect evidence as a starting point. And at least if you have that, then you can, if you go through court proceedings, then you've got discovery and you can work out for sure. But getting back to the sort of original question, you do have to look for indirect evidence, and that could come from observing something in action. Could be difficult in many cases. It could come from marketing material that the infringer puts out. It could come from things like regulatory disclosures. So, for example, in Europe we have the GDPR, and where what that says is that where you have algorithms making decisions that impact on people, you need to explain how those decisions are reached. Now, if somebody has to make a regulatory disclosure about their algorithm for the purposes of GDPR, that may give you at least some hints as to what they're really doing. Reverse engineering is a possibility. That's hard and probably unrealistic. So yeah, there's kind of all these indirect measures that you have to look for, at least as your starting point.
So, with quite a lot of risk to even patenting such AI technologies, we've actually seen a massive increase in patenting, especially in China. In the US, of course, is a bit, people are definitely still patenting, but China seems to be a major market for patenting of AI. So with that, why would, with all the downsides, why would people be so quick to just quickly patent their AI?
Yeah, well, I think one of the reasons comes back to what I touched on before, which is a marketing reason, right? So if you're, trying to show technology leadership in this area, so you're, a company that's not known for AI, like a financial services company or something, and you want to show, hey, actually, we have all this great technology, then filing lots of patent applications and getting them granted is a way to show that, to validate your technology and to validate you as a leader in that area. So that's definitely one reason. Another reason I touched on is, again, to sort of add value to your business, so to accumulate assets that add value. Another reason might be freedom to operate. So patent applications are published, right? So even if you don't get the patent granted, you have something which is disclosed, and that would prevent other people from patenting the same thing or something which is very close. So that enables you to continue practicing what you do without worrying about infringement of other people's patents, which you wouldn't have if you went the trade secret path.
Indeed. I I think that's actually one of the questions that was asked. So which is, and interestingly, this was dealing with the Mitsubishi patent that you shared. Everyone seemed to want to. I mean, the question suggests that people want to infringe on that patent. Not
Okay.
of course. But there's a question for the Mitsubishi patent. What would one do to bypass the patent? And someone else asked as well. Where is it? Yeah, if I think they were saying that the patent wasn't actually issued in Singapore. So if a Singapore startup or a Singapore company decides to create the same thing or practically identical technology, what's stopping Mitsubishi from attacking them or
Right.
trying to get a monopoly? Can we actually do that and bypass their patent?
Right. Yeah. Good question. So I'll do the first one first. So how do you get around the patent? That depends on the exact form of the claims, which I didn't put up on the slide. Basically, you would have to leave out something that is done as part of what they claim. So I only talked about the two main steps, those two main novel features of their invention, but there's other stuff in the claim that they do. So if some of those bits are optional for you and you can leave them out, that's one way to get around it. Now, the other thing to think about is they didn't get the same claims in every country. So they got quite a broad claim in the US, but in Europe, they had to narrow down to that specific encoder-decoder architecture that I showed on the slide, which was the example that they gave. So if you can use an alternative architecture, you would get around that claim in Europe. So you wouldn't infringe there. You might infringe in the US, you wouldn't infringe in Europe. And that kind of ties into the second question, which is the territoriality of IP rights, including patents. So if there's no patent filed in Singapore, making or selling something that would otherwise fall within the patent in Singapore won't infringe. You're absolutely free to do that. You cannot export the technology, though, to the US, to Europe, to Japan, where they do have granted patent rights. That would be where you'd encounter difficulties. But sure, you can do whatever you like in markets outside of those countries.
Indeed. I think to add to the question and just to quickly answer the question that was asked, I think one of the questions that follow on to that was, can you therefore patent what they've done overseas? I guess, correct me if I'm wrong, the quick answer to that is no, because it's probably prior art.
Correct, yeah. So that ties into the sort of freedom to operate point I made before. Because they've at least tried to patent, actually were successful in this case, because their patent applications have been published, they form prior art against any later attempts to patent the same thing. So if you tried to patent exactly the same thing in Singapore, Singapore examiner would find those Mitsubishi patents and say, your invention's not new because Mitsubishi have already done it, have already published it. So you cannot patent it.
So there's this added complexity. I think one thing that we did discuss prior to, when we were discussing planning this entire event was the need for a patent in a commercial sense. And I remember that we mentioned that when we look at, say, Shark Tank or Dragon's Den in the UK, I actually ever seen an episode. I'm sorry, everyone, this is a bit frivolous, of course, but I did see an episode where someone came in with a new technology and I was like, oh, wow, this is really cool. One of the investors said, oh, have you patented it? Do you have a patent? And to which they responded, we have patented it about a year ago and we are awaiting our patent. And the investors after that said, no, my question is, do you have a patent? And he said, no. Then you're not protected. What would you say to someone like that? Something like that.
Yeah, I think sometimes people don't understand kind of, what a pending application means compared to a granted patent. And pending application is still useful, right? Because as soon as it's published, that gives you some provisional rights. Because when the patent is eventually granted, which might be several years from the time that you file it, you can claim damages all the way back to the date that it was published. Right? So it has value throughout all of that time, even though it's not actually granted yet. having it granted just means at that point, yes, now you can enforce it and you can get monetary damages and you can stop others, get an injunction. But the pending application still establishes some provisional rights by virtue of its publication.
So, do you think education to investors is necessary, especially now that, we mentioned there's so many possible downsides, and if I really want to benefit from my AI, I just may decide that I don't want to patent it. So, how should one navigate that,
Yeah, well, I mean, that was really what that last slide was all about, was you need to make conscious decision in view of your commercial strategy, what you're going to patent, if anything, and what you're going to keep as trade secret, or maybe protect via some other IP rights, could even be trademarks, depending on what it is. But you need to explain what those choices are. You need to say, look, we haven't patented this bit because you'd never be able to find out if somebody's infringing or not, and we have doubts over the subject matter. So we held that back. But we have some important optimizations of our algorithm that nobody is ever going to be able to find out, and which make it work better than everything else that's out there. And we have this and this security measures for keeping that secret. Right? So that's one part of the strategy. Now, the other part of the strategy is, okay, we have an image capture device that we use to get data into the system to pass to the algorithm to produce its outputs. And that image capture device is configured in a special, novel way, which gives you less noisy input to the algorithm and gives you better results. We have patented that image capture device and the way of configuring it. Right. But so that's the other limb of the strategy. Now, it might be that you don't do that either, but again, you need to explain why you do these things.
That's really helpful. So I guess IP is just it's a lot more than just finding the solution to patenting. It's actually really finding the solution and game to play the game to protect the IP.
Correct, yeah.
Okay, everyone, we just have about 5 to 6 minutes, so we don't actually have time to deal with all your subject matter questions, but we will have another event on part 3 on the 5th of November, which we will try to answer your questions. Now, right now, I'll just go through a few. So my apologies if we haven't been able to clear your questions, all right? So Ashta actually asked quite early on about whether you can use an algorithm, right? If you have developed an algorithm and has multiple applications, can you actually use the same algorithm to patent for two technical applications?
Yeah, potentially. So that's the sort of platform technology example that I discussed. So yeah, I mean, you could have one example was the image processing example. So you have an algorithm that compresses images, and that will work on any kind of image, right? Any kind of application. So yes, of course, that could be patented. You could also have, an algorithm which has the same functionality in different contexts. For example, segmenting an image, or predicting biomarkers from a biological data set. Regardless of the actual application, the end application will still work in those different contexts in substantially the same way. Sure, you could patent that too.
Fantastic. So I'll just move on to the next question that was asked by Ying Ting. If I take an existing platform method and apply it to novel specific application where the said method has never been used before, would that be patentable?
Yeah, potentially. So, a new use for an existing thing can be patentable, right, as long as it's also not obvious. So, particularly if you have to make some adaptations to the existing thing to make it work in the context of the problem you're trying to solve, that certainly could be a new invention which is patentable.
Okay, so thank you for that question, Ying Ting. I'll move on to another question from Arun. So he asks, how does a FTO search for an AI-based algorithm, how is it conducted basically? Are there differences in the approach between FTO search for system and method versus AI algorithm?
Well, the way you'd conduct an FTO search for an algorithm would be essentially a search for that method, right? And the algorithm embodies a method, a series of steps. So that's what you'd be looking for. And so in that sense, it would be the same as any other FTO that you would do on any process.
Okay, thanks. One last question, I'll take it from Zhikang, who says, who's asking about the Microsoft patent. For the Microsoft patent, would including more details of how the deep learning model is used to generate the concept vectors so that it becomes an essential part of the patent helps overcome EPO's objection of no technical effect? Or how else would Microsoft have been able to overcome the objection in the EU if they could redraft their specifications?
Yeah, it would be still, I think, quite tricky in Europe because the output of the method, as I say, is a kind of considered to be non-technical, right? But if they had provided more detail about those deep learning aspects, and there was something about the way, like I said, if they were training the network in some special way, and that improved the way that the efficiency of the algorithm when run on a computer, that might have been able to get them over the line, possibly. But I still think it would have been quite tricky just because of the particular application in that case.
Thank you. So actually, that's all the time we have today. Thank you, Ken, so much for actually sharing with us and taking us through. As mentioned, apologies everyone if we didn't manage to get to your questions, but we will have a third session on the 5th of November where we can try to work out your IP strategy in a workshop edition. Ken will definitely be there. So if you want to ask some questions, feel free to meet us then or drop us an email. Okay, thank you everyone. That's all for today. We look forward to seeing you at our second session and a third session. With that, that's from Hello Tomorrow. Have a great lunch and we'll see you all soon. Please do feedback and give us some tips on how we can improve as well. Okay, good day everyone.